Welcome to The Thing About the Salem Witch Trials. I'm Josh Hutchinson.
This is Sarah Jack. On May 27, 1692, the new governor of Massachusetts, who had been in office for a week and a half, created a court of Oyer and Terminer, which means to hear and determine. This was a special court that would hear all manner of cases involving crimes committed in Essex, Middlesex, and Suffolk counties.
This week, we discuss why a special court was considered necessary, who was on the court, and how it operated.
A new charter had officially taken effect for Massachusetts in October 1691, but had just taken full effect when Sir William Phips was installed as governor on May 16th, and the Massachusetts Bay Colony had become the province of Massachusetts Bay. The new charter invalidated the colonial court system and laws, requiring a new set of courts to be established and a new set of laws passed which were not repugnant to the laws of England.
Massachusetts laws could not contradict English law, which was now effective in the province by default until the Massachusetts legislature made its own set of agreeable laws.
No trial had been held in Massachusetts since a copy of the new charter first arrived in Boston on February 8th. The jails were overcrowded. By now, at least 51 people were in the province's jail on witchcraft charges alone. An untold number of other prisoners crowded in with them. And in the coming days, more than a dozen other suspects would be arrested.
One witchcraft suspect, Sarah Osborne, had already passed away in Boston prison on May 10th. And with hordes of inmates packing the cells and typhus more common in warmer conditions, the summer promised to be deadly.
Governor Phips and his council needed to act to lessen the strain on the jail system. Phips had set the legislative session to begin on June 8th, but it would have been difficult to hold out until that date, especially with the witchcraft suspects being arrested by the gross lately.
Phips named Lieutenant Governor William Stoughton the Chief Justice of the court, with Justices Bartholomew Gedney, John Hathorne, Jonathan Corwin, Samuel Sewell, John Richards, Waitstill Winthrop, Peter Sargent, and Nathaniel Saltonstall serving under him.
Gedney, Hathorne, and Corwin were Salem residents. Haverhill, also in Essex County, Chief Justice Stoughton and Justice Richards lived in Dorchester. Winthrop, Sargent, and Sewell lived in Boston. They may be the Salem witch trials, but they were predominantly heard by judges from outside Salem.
These were the colony's elite men, not just Salem's. Though they had no formal legal training, they had learned on the job as justices of the colony's courts.
William Stoughton and Nathaniel Saltonstall were owners of large tracts of land and were nepo babies like many of the other justices. John Hathorne, Jonathan Corwin, Samuel Sewell, John Richards, and Peter Sargent were prosperous merchants. Prosperity was considered a mark of God's favor.
Gedney was a doctor. So was Winthrop, the son of former Connecticut Governor John Winthrop Jr. and grandson of former Massachusetts Governor John Winthrop, who was famous for his speech, A Model of Christian Charity, in which he described Massachusetts as a city upon a hill.
Stephen Sewell, Samuel's brother, was appointed clerk of the new court, and Thomas Newton was selected as King's Attorney General. Notably, Thomas Danforth was left off the court of Oyer and Terminer and did not serve in the role he is known for in Arthur Miller's The Crucible.
At least 4 of the justices who were appointed to the special court had prior experience with witch trials. Nathaniel Saltonstall, William Stoughton, Bartholomew Gedney, and John Richards all sat on the Court of Assistants that heard the case of Mary Hale, who was Sarah's ancestor, who was acquitted in 1681. And Stoughton was also on the acquittals of Mary Webster and James Fuller in 1683. He was joined on that Webster case by Bartholomew Gedney.
Unfortunately, records do not exist to show who was responsible for Elizabeth Morse's reprieve from a death sentence in 1680. We also do not have the records of which members of Edmund Andros government's council sat on the court for the trial of Goody Glover in 1688. However, Gedney, Winthrop, and Stoughton were members of that council, and Goody Glover hanged.
And the hanging of Goody Glover brought an end to 32 years in Massachusetts without a witchcraft hanging. It's significant to note again that the Court of Oyer and Terminer was to hear trials for all manners of crimes and offenses from Essex, Middlesex, and Suffolk counties, not only the witchcraft cases. And as we said, there were a lot of people in jail. Witchcraft is not even mentioned in the document that established the court, but the witch trials were a major focus as more than 150 people were jailed for that crime in 1692.
The court of Oyer and Terminer relied heavily on spectral evidence to convict. Witnesses detailed accounts of violent encounters with people's shapes or apparitions, called specters, which could only be seen by the people they were afflicting. This resulted in a great deal of single witness testimony about ghosts, basically, as evidence.
This was the primary evidence in the court. But in Connecticut in the 1660s, Governor John Winthrop Jr., the father of the Salem court's Waitstill Winthrop, and his friend, the Reverend Gershom Bulkley, had considered spectral evidence and ruled that in all cases, at least two witnesses must testify to the same event. This, in effect, eliminated spectral evidence in Connecticut long before the Salem witch trials.
But the court of Oyer and Terminer saw things the way Salem magistrates, John Hathorne and Jonathan Corwin, had seen them in the preliminary examinations of the accused. The suspects were guilty in their eyes from the moment their names were spoken, so any evidence would do. They used multiple accounts of separate events to say that multiple people had witnessed the defendants using witchcraft, even though those people had all seen different things at different times.
In June 1692, Governor Phips asked the Boston area ministers for their advice on how to proceed with the trials. They submitted the return of several ministers on June 15th, in which they encouraged the court to be cautious with spectral evidence, but then suggested that they vigorously prosecute those who had rendered themselves obnoxious.
Governor Phips disbanded the court of Oyer and Terminer in October 1692. During its 5-month lifespan, the court of Oyer and Terminer had a 100% conviction rate in witchcraft cases. It tried 27 people, and the trial juries found all 27 people guilty of witchcraft. They were all condemned to die, but 8 of them escaped with their lives. Elizabeth Proctor and Abigail Faulkner Sr. were pregnant and could not be hanged in 1692. They were slated to be executed after they gave birth in 1693.
And Mary Bradbury got out by escaping from jail in September 1692 after she had been sentenced to die. Somehow between that and the hanging date, she got out. And Anne Foster, unfortunately, died in jail in December 1692, nearly 3 months after she had been condemned to die. She and a few others were waiting for their death sentences to be carried out. Now, Dorcas Hoare was scheduled to die in September, but a group of ministers interceded on her behalf and won her an extra month to get right with God. So now she waited in jail with Mary Lacey Sr., Rebecca Eames, and Abigail Hobbs.
The temporary court of Oyer and Terminer was replaced by the permanent Superior Court of Judicature, which was created on November 25, 1692, and continues to exist today as the Massachusetts Supreme Judicial Court, the oldest appellate court in continuous existence in the Western Hemisphere.
On December 7th, William Phips appointed the judges for the Superior Court. He, surprisingly to me, made William Stoughton the Chief Justice again, and also put Oyer and Terminer Justices Samuel Sewell, Waitstill Winthrop, and John Richards on the court, along with former Deputy Governor Thomas Danforth, who finally had a role in the Salem witch trials.
The Superior Court tried the remainder of the Salem witch trials in the first 5 months of 1693, with the final person released from jail in May after Governor Phips issued a general release of all witchcraft prisoners.
The Superior Court's conviction rate was under 6%. 52 cases were heard, and only 3 women who were confessors were convicted. The primary reason for the dramatic difference in conviction rates under the two courts is that spectral evidence was no longer considered proof of guilt in the Superior Court.
And I find it interesting that the return of ministers was just weeks after the court of Oyer and Terminer went into session. So they were almost immediately looking at that.
Especially with the conviction of Bridget Bishop the first day that the court was in session, they needed to evaluate what kind of evidence constituted a proof of witchcraft.
Allegations of assault by the shapes, apparitions, or specters of innocent people dominated the proceedings of the court of Oyer and Terminer, with individual witnesses relating accounts of attacks, which were most often not corroborated by any other witnesses.
Because only the afflicted could see the specters while others could not, you had to believe 100% in the credibility of the afflicted persons to buy their stories.
Or
Be so fearful of witchcraft that you just bought anything.
And accept the authorities' support and push for the spectral evidence. I mean, it was these men writing the complaints and the judges examining the accused witches. In January 1693, the Superior Court convicted Sarah Wardwell, the widow of executed Samuel Wardwell, who said she had used her baby as a puppet to harm others by squeezing them. Elizabeth Johnson Jr., the 22-year-old granddaughter of Reverend Francis Dane of Andover, who had confessed to many acts of witchcraft. And Mary Post, who had also confessed. Interestingly, Mary Post's sisters, Hannah and Susanna, had also confessed, but were not convicted.
Following these convictions, Chief Justice William Stoughton signed a death warrant on January 14, 1693, for 8 individuals. This list included the 3 women convicted in January, as well as 5 others who had been convicted in 1692 but had remained in jail, such as Elizabeth Proctor and Abigail Hobbs.
The executions were scheduled for February 1st. However, Governor William Phips stepped in the day before the hangings were to take place and issued a reprieve for all 8. Chief Justice William Stoughton was reportedly so enraged by his obstruction of what he considered justice that he walked off the bench in protest, declaring that the kingdom of Satan was being advanced by Governor's mercy. And I believe he said they had basically been on target for clearing the colony of witches.
His quote, to be exact, was, "We were in a way to have cleared the land of these. Who obstructs the cause of justice, I know not, but thereby the kingdom of Satan is advanced. The Lord have mercy on this country."
He walked off the court and did not return during the session. He was replaced as Chief Justice by Thomas Danforth, the former deputy governor, made famous by Arthur Miller's The Crucible, a highly inaccurate portrayal of Danforth's actual role in the witch hunt.
Stoughton did eventually return to the court on April 25th, 1693, when it began a session in Boston to hear Suffolk County cases, and the Superior Court finished its witchcraft business in May 1693 with the clearing of Tituba by proclamation, and then the jails were cleared once the jail fees were all paid, because back then, you didn't just go to jail, you paid for your jail, you paid for your food, you paid for the shackles that you were chained to the wall with.
The Court of Oyer and Terminer is in session at the end of May 1692. If you want to find out what's happening day by day through June in the Court of Oyer and Terminer, tune into our podcast, Salem Witch Trials Daily.